So, imagine your city passes a zoning law tomorrow, right? And it just instantly wipes out half the value of your property.
Oh, yeah, you'd be absolutely furious.
Right. And you would probably think that the Constitution guarantees you a check from the government to make up the difference.
Of
I
course.
mean, we all know the whole they can't take your property without paying for it rule. But today, well, we are going to explain why you won't get a single dime.
Yeah, it is, frankly, a pretty harsh reality check.
It really is.
Because the gap between what we assume our constitutional rights are and, what the courts actually enforce is massive.
Welcome to the deep dive. Our mission today is to decode this really complex world of constitutional law, specifically zooming in on individual rights.
And we've got some great material for this.
We do. To do this, we are looking at two highly detailed constitutional law review outlines. And we have something incredibly valuable in our stack of sources today.
Oh, the MBE notes.
Exactly, a set of MBE tricks and issue spotting notes.
Yep.
These are the famous Grossman enhanced rules.
Yeah, these are the literal cheat codes. I mean, law students use these exact frameworks to navigate the brutal multi-state bar exam.
Right, because they cut through all the noise.
Exactly. They cut through the abstract philosophy to find the mechanical triggers and traps that actually decide cases.
Which means, for you listening, we are bypassing the dramatic courtroom speeches today. If you follow this stuff, you already know the big concepts anyway.
Right, the Hollywood version.
Yeah, so we're going to dig into the obscure shortcuts lawyers use to spot the traps. We'll see how the Constitution actually operates when the rubber meets the road.
I love it. Where do we start?
Okay, let's unpack this. Because before we can look at a specific right, we have to look at the very first hurdle, the gatekeeper.
Ah, yes.
The state action requirement.
Right, the threshold rule. Because the Constitution, generally speaking, is designed to protect you against government action.
Just the government.
Exactly. It does not regulate purely private conduct. If there is no state action, there is no constitutional individual rights violation to even discuss.
It's just over.
The analysis literally stops before it starts.
So state action is basically the bouncer at the club of constitutional rights.
That's a great way to put it.
If the entity restricting your speech or discriminating against you is a private party, you aren't even getting in the door to us your case.
And, if you try to bypass that bouncer by pointing at a private business, say, like a private restaurant discriminating against a patron, and you start shouting about the 14th Amendment, you fail the test.
Because the 14th Amendment only applies to states.
Exactly. To go after private discrimination, you'd actually have to rely on federal statutes passed under the Commerce Clause or maybe the 13th Amendment.
Because the 13th Amendment prohibits slavery and its badges and incidents anywhere, right? Not just by the government.
Right, everywhere.
Right.
But that's a different avenue.
Now, the Grossman notes emphasize a major trap here for issue spotting. A lot of people assume that if a private entity is heavily regulated.
Oh, this is a huge trap.
Yeah, or if they get government money or have a state license, they somehow magically transform into a state actor.
And they absolutely do not. The government has to be significantly entangled in the specific unconstitutional act itself or actively coercing the behavior.
So just existing with a license isn't enough.
No. Handing a private school some grant money or issuing a liquor license to a private club does not turn that private club into the government.
But wait, what if a corporation gets so big and powerful it practically replaces the government?
Like what?
Like a massive tech campus that has its own security, its own housing, its own internal rules, or an old mining town where the company owns literally every building and the streets.
Okay, yeah, the courts did anticipate that danger.
Yeah.
They won't let the government outsource its tyranny to a private shell company.
Okay, good.
This is known as the public function exception. If a private entity is performing a task that has been traditionally and exclusively done by the government, like running a literal company town or conducting a public election, the private conduct gets treated as state action.
But the key word there is exclusively.
Exactly. Just providing a public service, like running a private utility company, isn't enough to make you a state actor.
Got it. So we show our ID to the bouncer, we prove the government is the one pulling the strings, and we get into the club.
We're in.
The government is acting. Now, what happens when they try to restrict a fundamental right or take something away from you?
So now we enter the realm of due process. And the Grossman shortcut for spotting this is beautifully simple.
I love a good shortcut.
You just ask, who is being burdened? If the government is regulating a right for all people, you are dealing with due process.
Okay.
But if they are denying a right to some people but not others, you pivot to equal protection.
So let's start with the everyone rule. Due process splits into two distinct concepts, right? Substantive and procedural.
Yep.
Substantive due process is the what. What is the government trying to take away, and do they have an adequate reason for doing it?
And the courts evaluate that reason based on how fundamental the right is. Fundamental rights trigger strict scrutiny.
The highest bar.
The highest. The government has to prove their law is narrowly tailored to achieve a compelling state interest.
The sources list the heavy hitters here. Marriage, voting, procreation, the custody of your children.
All fundamental.
But the notes flag some major counterintuitive traps. Let's look at interstate travel.
Oh, this one catches everyone.
Right. The Grossman notes specifically warn that this fundamental right means state-to-state travel. It does not protect your daily commute.
Yeah, a lot of challengers try to argue that, like, a local curfew or a traffic camera violates their fundamental right to travel.
And it doesn't.
It doesn't. The core constitutional protection is against a state penalizing new residents. The whole mechanism here is about preserving a unified nation.
Okay, that makes sense.
So if a state tells new arrivals, you can't receive basic welfare benefits until you've lived here for 12 months, that law gets hit with strict scrutiny because it functionally punishes the act of moving between states.
Now, the outline also gives a stark current law caution regarding what does not make the fundamental rights list.
Right, things change.
Yeah, public education is not a federal fundamental right. And, post-Dobbs, neither is abortion.
And that distinction dictates the entire outcome of a case. If a right isn't fundamental, the court drops the standard of review all the way down to the rational basis test.
Which is completely different.
Most economic and social regulations live down here in rational basis.
Under rational basis, the government just needs to show a conceivable, legitimate reason for the law, right?
That's it. They basically say, hey, we thought this might help the economy, and the court just rubber stamps it.
The bar is literally on the floor.
On the floor. So that is substantive due process, the substance of the right, but procedural due process is the how.
And the cheat code here is that procedural due process has 0 levels of scrutiny. No strict scrutiny, no rational basis.
Nothing like that.
It just asks one mechanical question. Did the government intentionally take your life, liberty, or property without giving you notice and a meaningful opportunity to be heard?
But, and this is a big but, you have to possess a recognized property or liberty interest in the first place to trigger that requirement.
Okay, let's walk through a messy hypothetical based on the text. Say I land a job with the state government.
Congratulations.
Thanks. But it's a trial period, probationary role.
Yeah.
6 months in, my manager fires me. No warning, no hearing. I am just out on the street.
Okay.
I argue my procedural due process was violated because they took my job without a hearing. Am I right?
What's fascinating here is how the law defines property. You hoping to keep your probationary job is merely a unilateral expectation.
Meaning I just wanted it really bad.
Right. To trigger procedural due process protections, you need a legitimate vested entitlement.
So because my contract explicitly said probationary, I hadn't vested. I wasn't legally entitled to the job yet.
No entitlement means no property interest. And if there is no property interest, the government can fire you without a hearing, and the Constitution has absolutely nothing to say about it.
Wow. That makes the mechanics crystal clear. All right, so substantive due process handles laws that restrict rights for everyone. What happens when the government plays favorites?
When they treat groups differently.
Yeah. When a law burdens Group A, but lets Group B off the hook.
Then we trigger the Equal Protection Clause.
Right. Denial to everyone equals due process. Denial to some equals equal protection.
Spot on.
The courts analyze this using the tiers of scrutiny. And instead of the old grading a test metaphor, let's think of these tiers like a microscope. Depending on who the government is discriminating against, the court uses a different lens.
I like that. That analogy works perfectly for the mechanics. Let's start with the electron microscope. Strict scrutiny.
The strongest lens.
Yes. The government almost always loses here. This applies when the government classifies people based on race, ethnicity, or national origin.
And the why behind this is vital. The courts apply strict scrutiny to race because it is an immutable characteristic.
You can't change it.
Right. And historically, racial minorities have lacked the political power to protect themselves from hostile majority legislation.
So they need the court's maximum magnification to ensure the government isn't acting out of prejudice.
Exactly. The government has to prove exactly why every single element of their discriminatory law is absolutely necessary for a compelling interest.
But there is a massive MBE trap here regarding how you prove the discrimination exists in the first place.
Oh, let's test this. Say a city passes a hiring test for firefighters that is totally neutral on paper, but in reality, statistics show it disproportionately screens out one specific racial group.
Okay.
The impact is clearly discriminatory. Does that trigger the electron microscope?
Discriminatory impact alone is never enough under the Equal Protection Clause.
Really?
Never. You have to prove discriminatory purpose alongside that effect. The challenger has to show the government chose that policy, at least in part because of, not merely in spite of, its adverse effects on an identifiable group.
So if the city just wanted a rigorous physical test and didn't actually intend to discriminate, what happens?
It drops all the way down to rational basis.
Wow. Okay, next tier down is intermediate scrutiny. The court swaps the electron microscope for a strong magnifying glass.
Still strong, but not impossible to pass.
Right. This applies to gender and legitimacy, meaning whether a child's parents were married.
And for gender, the mechanism requires the government to show an exceedingly persuasive justification.
They can't just use stereotypes.
Exactly. They cannot rely on overbroad, archaic generalizations about the roles of men and women. The law must be substantially related to an important government interest.
And finally, we drop down to the naked eye. Rational basis.
The easy tier.
This applies to classifications based on age, disability, and wealth.
Yep.
The reason age only gets rational basis is that age isn't an immutable minority status in the same way. Everyone gets older.
Right. The political process naturally protects against age discrimination because older voters have significant political power. And under rational basis, the burden actually flips. The challenger has to prove the law has no rational relation to any legitimate government interest.
Now, if you're listening and thinking, so the government can just do whatever it wants to these groups, there is one critical limitation the Grossman notes highlight.
Oh, the animus rule.
Yes. Animus toward an unpopular group is never a legitimate government interest.
Even under rational basis, sheer hostility doesn't count.
You can't just hate them.
Right. You cannot pass a law simply because the majority dislikes a specific minority group. The court will strike that down even with the naked eye.
Now, I want to flag a wild contradiction I found in the notes regarding alienage, classifications based on citizenship status.
Oh, the alienage trap. It catches almost everyone off guard.
The sources say if a state government passes a law discriminating against non-citizens, it generally triggers strict scrutiny.
Yes.
But if the federal government passes a law discriminating against non-citizens, it only gets rational basis review. That feels totally backwards.
It does seem that way, but it makes perfect sense structurally when you look at the mechanism of federalism.
How so?
The Constitution grants the federal government plenary power over immigration and naturalization. It is literally Congress's job to make rules regarding non-citizens and the borders.
Ah, okay.
The states, however, have no such power. When a state tries to regulate based on citizenship, the courts look at it with deep suspicion, pulling out the electron microscope.
Because it's not their lane.
Exactly. It's all about who holds the power.
Okay, we've navigated the gatekeepers, we've covered personal liberty and equality. But property isn't just about abstract rights.
No, it's very tangible.
It's about your physical stuff and the deals you rely on to make a living. How does the Constitution handle the tangible world?
This brings us to the Takings Clause and the protections for your economic agreements.
The Takings Clause rule is drilled into our heads. The government cannot take private property for public use without just compensation.
And the notes lay out the clear triggers for this.
Right. If the government permanently physically occupies your land, even just like running a cable wire across your roof, that is a taking.
Absolute.
Or if they pass a regulation that wipes out 100% of the economically beneficial use of your land, an inverse condemnation that's a taking.
But the tricks outline points out two major traps here.
Lay it on me.
First, the definition of public use is interpreted incredibly broadly. They do not have to build a public park or a highway.
What else counts?
A rational public purpose is enough. If the city decides that seizing your blighted property and giving it to a private shopping mall developer will revitalize the local economy.
That counts as public use.
The courts generally consider that a valid public use, yeah.
Wow. And the second trap brings us back to my example from the very beginning of the deep dive. The city passes a zoning law, and your property value drops by 50%.
Here's where it gets really interesting. A mere reduction in property value is not automatically a taking.
Because you still have some value left.
Right. Because you haven't lost all economically beneficial use, the court applies a balancing test known as the Penn Central Factors.
What do they look at?
They analyze the economic impact on you, the character of the government action, and crucially, your reasonable investment-backed expectations.
Meaning, did you buy the land reasonably expecting to build a factory, or was it already zoned residential when you bought it?
Exactly. The courts view a partial drop in value as simply the inherent risk of owning property in a regulated modern society.
Tough luck, basically. So we've established the government can regulate your physical land. But what about intangible property, like a contract?
Oh.
If the government passes a law that ruins a business deal I made, am I protected?
You look to the Contracts Clause. It prohibits states from substantially impairing existing contractual obligations.
But there's a catch.
Notice the specific mechanism. It explicitly prohibits states. It does not apply to the federal government.
Oh, wow.
And it only applies to existing contracts, not agreements you hope to make in the future.
The text highlights another retroactive trap that we hear on TV all the time. Ex post facto laws.
Yes. People assume this means the government can never pass a law that retroactively changes the rules on you.
Right. That's the common assumption.
The historical context here is key. The founders drafted the ex post facto clause specifically to stop the government from retroactively punishing political enemies.
Meaning jail time.
Exactly. Therefore, it only applies to criminal or punitive laws. It does not apply to ordinary retroactive civil legislation.
So if Congress retroactively changes the tax code, or alters civil liability rules, costing your business millions, ex post facto will not save you.
Not at all. Civil law constantly adjusts economic burdens. Only criminal law triggers that specific constitutional shield.
The cheat codes really reframe everything.
They do.
Okay, let's look at the ultimate individual right, the mind and the mouth, the First Amendment.
My favorite.
The courts use incredibly structured formulas to analyze speech and religion. Let's start with religion.
The First Amendment contains two distinct clauses here, free exercise and the Establishment Clause.
For free exercise, the expert shortcut is fascinating. You might assume that if a law burdens your religious practice, it's inherently unconstitutional.
It seems like it should be.
But the notes clarify that neutral laws of general applicability are usually valid, even if they incidentally burden religious conduct.
The classic example is a state banning the use of peyote for everyone due to health and safety concerns.
Right.
If your religion uses peyote in its rituals, the law is still valid because it is a neutral blanket rule. The government isn't targeting your faith.
It just catches you in the net.
Right. It's only when a law is specifically designed to suppress religious practice that it triggers strict scrutiny.
Then there's the Establishment Clause, which prevents the government from formally sponsoring, coercing, or favoring religion in a way that is inconsistent with historical practices.
Right. They can provide generally available benefits like fire protection to a church on neutral terms. But they cannot compel citizens to participate in a state-sponsored prayer.
Now we pivot to speech. The Grossman outline distills decades of chaotic First Amendment jurisprudence into a brilliant three-step framework.
It really is brilliant.
Step 1. Is the speech protected or unprotected? Because not all speech gets a constitutional shield.
Nope. Unprotected speech includes true threats, obscenity, and fraud.
And the outline highlights a crucial logical distinction between two forms of unprotected speech: fighting words and incitement.
This is a great distinction.
Fighting words are individual-facing. It's language directed at a specific person, face-to-face, that is likely to provoke an immediate violent reaction.
Like trying to start a bar fight.
Exactly. Incitement, on the other hand, is crowd-facing. It's speech directed to producing imminent, lawless action from a group, and is likely to actually produce it.
Once you determine the speech is protected, you move to step 2. Is the government regulation content-based or content-neutral?
Content-based means the government is trying to suppress the actual message.
And if they do that, they get hit with strict scrutiny. They have to prove a compelling interest, which they almost never can.
But content-neutral is completely different.
Yes. Content-neutral regulations are just time, place, and manner restrictions. The mechanism here isn't about suppressing ideas, it's about the government managing logistics.
So it is the city saying, we don't care if your protest sign is pro-war or anti-war, you just cannot use a bullhorn in a residential neighborhood at 3 in the morning.
Exactly. Because they aren't attacking the message, it only gets intermediate scrutiny. The city just needs a significant interest, like peace and quiet.
And they must leave open alternative channels for you to communicate your message during the day.
Which logically leads to step 3. What is the forum? Where is the speech happening?
Right. Is it a traditional public forum, like a park or a public sidewalk? Or a non-public forum, like the inside of a DMV or a military base?
In a public forum, the government's power to restrict your speech is extremely limited.
But inside a non-public forum, the restrictions just need to be reasonable and viewpoint neutral.
You can't hold a massive rally inside a government office building because the space is dedicated to a specific government function.
Now, the outline also flags how poorly drafted laws can accidentally violate the First Amendment using 2 specific concepts.
Vagueness and overbreadth.
A law is void for vagueness if an ordinary person cannot figure out what is actually prohibited. This creates a chilling effect where people just self-censor because they don't want to risk going to jail.
And overbreadth is different. A law is overbroad if it attempts to ban unprotected speech, but sweeps in a substantial amount of protected speech along with it.
For you listening, the cheat code to spot an overbroad law, whether on a test or reading the news, is to look for sweeping words like any or all.
Oh, those are the red flags.
If a city ordinance bans all First Amendment activities inside the airport terminal, that is massively overbroad. It would ban someone wearing a political T-shirt or quietly reading a newspaper.
It sweeps in far too much protected conduct to survive.
We have covered a massive amount of ground today. We started with the bouncer at the club of state action, moved through the microscopic lenses of equal protection, and charted the 3-step framework of free speech.
And when you synthesize these MBE tricks and rules, you realize constitutional law is an algorithm.
Really, it is.
You identify the actor. Is there state action? You identify the affected group. Is the burden on everyone triggering due process or just some triggering equal protection?
And finally, you determine the level of scrutiny based on the specific right or classification.
Exactly.
With these Grossman shortcuts, you can look at any legal drama and bypass the emotional rhetoric. You can actually see the matrix of the law underneath.
But, studying these mechanics leaves us with a profound final thought.
Yeah, lay it on me.
We culturally view the Constitution as an impenetrable shield protecting the individual from the state.
That's the mythos, yeah.
But when you look closely at these rules, like the rational basis test where the government almost always wins, or the time, place, and manner restrictions where they dictate the logistics of your protest, or the Penn Central factors allowing your property value to plummet,
Right.
how much of constitutional law is actually just a detailed instruction manual for exactly how the government is allowed to regulate us, rather than a total ban on regulation itself?
Wow. Is it a shield for the citizen or just a handbook for the bouncer?
That's the question.
That is definitely something to chew on. All right, that is our deep dive for today. Keep an eye out for those cheat codes, and we will catch you next time.